Morning, everyone. I call this meeting to order. This is a resumption of the hearings of the Standing Committee on Justice Policy to conduct hearings on Bill 161, an act to enact the Legal Aid Services Act 2019, and to make various amendments to other acts dealing with the courts and other justice matters. Today's proceedings will be available on the Legislative Assembly website and the television channel. And we have the following members present. First of all, for members in the room, to my right is MPP Lindsay Park. To my left is MPP Lucille Couillard. And please note that you will be able to see them through your Zoom link whenever they have the floor. We also have the following members participating remotely. We have Will Bauma. We have MPP Parm Gill, we have MPP Morrison, MPP Singh, MPP Tangri, MPP Rick Nichols, MPP Way, and also I understand that MPP Yard has now joined. MPP Yard, could you kindly confirm that you have joined?
Thank you, Chair. It's MPP Yard, and I am in Brampton North.
Thank you so much.
You're welcome.
We're also joined by staff from Legislative Research, Hansard, Interpretation, and Broadcast. Please make sure you speak slowly. Ask any questions if you have any issues. And please be recognized to speak. Since it could take a little bit of time for your audio to come on, please take a minute before you begin. And as always, I kindly ask that all comments by members and witnesses are made through the chair. Unless there are any questions before I begin, if we could please unmute everyone. Any questions or issues or preliminary business? Seeing none, I understand that our first panel, our 10 a.m. panel, has already come online. And I will now invite them to appear before the committee. And specifically, we have the Durham Community Legal Clinic, Omar Harrieti, the Executive Director, and Aranthis Jigathasan, Staff Lawyer, Mayor Mechanic, Waddell Phillips Professional Corporation, specifically John Phillips, and Margaret Waddell, I understand, appearing again through a different capacity. So welcome, everyone. The format for today's proceeding, as agreed upon and articulated in the report of the subcommittee, is the panel will appear jointly. 7 minutes for each presenter to begin, and followed by questions from the two recognized parties and the independent member. So I would invite the Durham Community Legal Clinic to commence their submissions, specifically by stating their name for the record.
Good morning. My name is Omar Harrieti, H-A-R-E-D-E-Y-E, first name O-M-A-R, and I am the Executive Director for the Durham Community Legal Clinic.
And good morning. My name is Aravin Jagathisan. I am the staff lawyer at the Durham Community Legal Clinic.
Welcome. Please begin.
Good morning, and thank you for having us here today. It is a pleasure to be here and to be able to comment on Bill 161. In the review of the agenda, I have noticed that there are indeed many clinics appearing today, and my hope is that the committee come to the conclusion after hearing all of the submissions that the clinics themselves are very different in their nature, and that is very much by design. A little bit of background about the communities that we serve. We serve a population of over 650,000 people, over 2,500 square kilometers. The motto is a great place to grow, and indeed the region is growing very rapidly in the western parts of our catchment. It increasingly looks like an urbanized area, similar to Toronto, whereas in the eastern and northern parts of our catchment, it is still very rural. And so there are obviously some diverse and unique considerations depending on what part of the catchment area that we're looking at. We also work very closely with our local politicians, to include the president of the Treasury Board, the Minister of Finance, the Chief Government Whip, the Deputy Speaker, and the PA to the Attorney General, who of course is on the committee. These are collaborative relationships, and we work consistently with them not only to facilitate services to the communities, but also in terms of legislative amendments, such as Bill 161. And it is important, of course, that we do that in a nonpartisan way. And so we work with every government. We also work with every opposition, and that is for every government or every opposition that might be in place. There are some components of Bill 161 that we have supported, and that's not what we would like to use our time for here today. It's to make more pointed recommendations about how it can be improved. We have provided some substantive written submissions that I would hopefully direct to the committee to review at their leisure in greater detail. I will note that it is positive that there are elements of this initial draft of the bill that have been modified, in particular the role of the communities and the boards in relation to the clinics. But we do strongly believe that there is more of a need for greater autonomy and independence in community legal clinics than what is currently enunciated in Bill 161. These are principles that, if I can point back to, go all the way back to the very inception of community legal clinics in the Osler Report. And so we're looking at almost 50 years of many different governments, several reviews, very, very comprehensive reviews at that have all reaffirmed and emphasized the importance of that independence and that type of model. And I think that it is of some concern that that model would be so drastically changed in such a short period of time without proper review and consultation. And to put that in perspective, the previous review that occurred under the Osler Report entailed 285 written submissions and heard 105 oral submissions over 3 months and in 10 different centers across the province. That is a very, very extensive review, and it's not the type of review that unfortunately we've seen in light of Bill 161. And so that is one of the main principles or messages that we would like to convey to the committee, is that these principles have worked very well for the clinics, that they have ensured that there is autonomy in a way that prevents them from being dictated to, if you will, based on the principles or priorities of whatever government might be in power. And most importantly, it has allowed clinics to maintain a very close relationship to low-income populations. And this is important. This is actually enunciated again in the Osler Report, that low-income populations typically have an inherent distrust, not only for lawyers in the legal system and the justice system, but also for government at large. What that means from a practical perspective is that they may not engage with government services that will actually ameliorate their poverty, that can actually assist them in the circumstances and the situations that they're in. But because of that distrust and because they feel removed from a system that is there, they don't access those resources. And so community legal clinics play a very important and crucial role in having those linkages and channels to those communities, and also then being able to convey those perspectives to policymakers and governments as well. There's an additional concern about constraining or restricting the definition of poverty law in Bill 161. And I think we can use the example of our clinic, which was founded in 1985. In the early days of our clinic, the bulk of the work very much focused on income maintenance. We've seen that drastically change, especially over the past 5 years. And the largest area of services that we currently provide is in housing law. And I'll emphasize that the fact that we provide services in the area of housing law doesn't necessarily mean that it's increasing the expense, for example, for landlords. In fact, our experience is that it's quite the opposite, that by assisting tenants, we actually give them the tools that allow them to access those tribunals and inform them in the best way to do so. Without legal representation, they often create unnecessary delays, and more importantly, and in light of the broader considerations, create additional expenses for landlords who are struggling then with tenants who already feel disenfranchised and frustrated with the system. And so it's not simply an adversarial role that the community legal clinics play. In fact, it's always expected and intended to be far beyond that, and to assist and educate and facilitate resolution and to ultimately lift individuals out of poverty. That is a nonpartisan goal. That is a goal that is shared by all political parties, I would hope. And in particular, it is important for any community legal clinic to be responsive to the government of the day and the priorities that are being enunciated. And in our written submissions, we make reference explicitly to the 2019 budget at page 44 and the principles that are enunciated there. And we actually detail in great length the extent to which we are trying to be responsive to those government priorities in facilitating access to justice and alleviating poverty. So
Please conclude.
thank you for having us, and I'm happy to receive any questions if there are questions from the committee.
Thank you so much, Omar. Thank you. We'll now begin with questioning, and we'll follow the order on which we were yesterday. So that will lead us to the official opposition beginning its questioning with 5.5 minutes, and I'll recognize MPP Singh.
Thank you so much, Chair. My first question is for Omar. Omar, my question to you is as follows. Would you agree that the removal of low income, the removal of disadvantaged communities, the removal of, my apologies, there's a phone ringing in the background here, the removal of, and the narrowing, rather, of the practice areas for this proposed Bill 161 would actually disadvantage Black communities, racialized communities, and women fleeing domestic violence with respect to the changes that are happening in Bill 161 and actually create a greater disadvantage to those communities in accessing justice?
Certainly. We detail some of this in our submissions, and so for the members of the committee that are looking for that, you can see that starting from page 7. So we do have some very significant concerns around the removal of that language, which very much frames the mandate of community legal clinics. Access to justice is an enormous issue across Canada. We have been in an access to justice crisis now for many years, and there's no dispute about that crisis at every level of government, in every corner of the judiciary and the bar. Community legal clinics play a crucial role, and as I emphasized, that government and even the profession, the bar, vast majority of lawyers do not have the close ties and the meaningful relationships with marginalized populations and with low-income populations. We need to facilitate those relationships, not only to alleviate the poverty, but also to inform legislation as to the detrimental effects that it may have on those communities. So it is, in our submission, absolutely essential that that type of language be retained in the future act.
And further, specifically with respect to right now we're seeing across the world folks who are coming up to rise up against anti-Black racism, just to narrow on that point specifically, would you say that the removal of access to justice, disadvantaged communities, low-income communities, could disproportionately negatively impact Black communities trying to access justice and further propagate systemic anti-Black racism within our province?
This isn't speculative for us. Based on our experiences, we know, and we're seeing this during COVID-19, marginalized populations will invariably experience the worst of any inequity, and we're seeing it right now. And so, in more directly to your question, we do have issues of racial profiling and challenges in terms of friction with the Black community in areas of Whitby and Ajax, in particular in our area. And that has been documented. There have been incidents. And there is a concern, of course, that if our mandate is in some way shrunk or restricted by LAO, then we're unable to facilitate not only those relationships, but also the more crucial issues that are needed in terms of reforming our justice system and having our law enforcement system working collaboratively with our communities to keep them safe, as opposed to an oppositional type of relationship, which we're very much going to see as these concerns increasingly rise and come to the forefront.
Finally, would you agree with the statement that the positives of modernization that are in Bill 161 are outweighed by the negatives, and with respect to what we've outlined earlier, the removal of access to justice, the narrowing of the practice areas, and looking as a whole, Bill 161 will actually, would you agree with the statement that the negatives outweigh the positives, and further, it could create a step back with respect to access to justice for Ontario, as it is written right now and proposed?
The biggest challenge there, and we start that from page 19 of our written submissions, is in the way that it's structured, and starting really from page 21, where we detail that in terms of the timelines that we're looking at. 6 months after this bill is passed, the LAO has the ability to enter into negotiations of the contracts with the community legal clinics, and that is in a very abbreviated timeline, especially when we're looking at COVID-19 and the pandemic. And so the balance in our submission really is not properly considered, and if it does proceed as it currently is constructed, we have very, very significant concerns that clinics will be disrupted, the services that we provide will be disrupted, and this isn't an issue of, again, partisan perspectives. We do provide frontline services all the way from the executive director, that's myself, to support staff in every aspect of our clinic, because that's the only way that we can operate. And so there will be significant impacts on the services that we provide if this proceeds in this manner.
My understanding is we probably around 30 seconds left. So in the final 30 seconds, are you able to just articulate the cuts to legal aid that were made previously, just very briefly, how negatively they impacted your clinic?
So I think we were prospectively fortunate in that we received an effective 1% cut as opposed to 22% at some clinics in Toronto. But what I would say is that 1% cut was devastating. Staff morale has plummeted. We've had enormous turnover. I'm new to my role as of September of last year, and it has impacted the service that we provide because we are very lean, we provide very efficient services, and the clinic system is incredibly interconnected. So cuts elsewhere in the system has a very immediate and direct impact in terms of what we do in Durham Region.
Thank you very much. We'll now proceed with 5.5 minutes of government questioning. I'll recognize MPP Park.
Thank you, Chair. And thanks for joining us, Omar. We've had a number of good discussions. I know you've come down to Queen's Park a number of times since taking on the role of Executive Director. I just wanted to jump into one of the specific things you mentioned in your back and forth with MPP Singh, specifically talking about the commitment of Legal Aid Ontario to continue to provide access to justice to low-income Ontarians. And I think what I heard from you, and we've heard from different stakeholders, is that the new legislation should specifically refer to these principles. So I wondered if you could just comment on your perspective on the need to include these concepts in the legislation itself.
Certainly. I will go back to the comments that I said previously, which is that the role of community legal clinics are not to simply provide legal services and representation. It's obviously a very important part of what we do, including for members of your constituency, but it is also to inform, as I've described, the legal system and policymakers and governments as to the impacts that law reform have on low-income and marginalized populations. We need that expressly indicated in the legislation because obviously there's an intermediary here between government and the community legal clinics, which is Legal Aid Ontario, which has its own challenges. And what we're very much concerned about is, and we saw this with the recent cuts, that those challenges will be disproportionately put on our laps as opposed to somehow being resolved within LAO. And so it is essential that we maintain that mandate of access to justice because it then gives us an ability in our negotiations and our discussions with LAO to once again affirm that the role of community legal clinics isn't simply to provide services and that it's to assist them, Legal Aid Ontario, as well as other partners within the justice system in finding creative and innovative solutions. And that doesn't necessarily mean asking for more money. And so, as you know very well, in our clinic and the development of the hub that we're doing that's detailed in our written submissions, we are breaking down silos, we are cutting red tape, and we have been increasing the focus on the client and the members of the community. And that is really what we very much should be continuing to do in our conversations with our funder, and having this wording in the legislation assists us in doing that.
Thanks, Omar. And I think, I mean, the Attorney General's made many public statements, and I have in many discussions I've had with stakeholders on the importance of community legal clinics, and there's no question you're doing terrific work in serving the most vulnerable in Durham region. Specifically, you mentioned I think you're referring to the definition of community legal clinics in the legislation. Maybe you can speak to how important it is that definition specifically reference clinics' boards of directors and that it be comprised of members of the community or communities the board serves?
Yeah, so this has been going back to the Ulster report and the Grange report, and every review that has occurred for community legal clinics, the board of directors should be grounded in the community, but not just grounded in the community in terms of residency, but also have some meaningful involvement. And the reason for that is, for all of the reasons that I explained earlier, is that the community legal clinics are themselves very, very diverse across the province of Ontario. The needs of those communities are very diverse. And so in our area, in Durham region, we obviously have the GM plant and the job losses over past years as it relates to that, which has required us as a clinic to start to offer more services in the area of employment law, WSIB, human rights law, but not just in terms, again, of legal representation. It's about also assisting those individuals then in finding new jobs, in getting back on their feet, becoming taxpayers who can contribute towards society in a meaningful way. Those are unique and specific needs to our community that may not be identified or reflected elsewhere across the province. And so that's why the governance and the decision-making and the prioritization needs to really occur within the community legal clinic level. And the definition of poverty law, if I can speak to that, the definition of the poverty law in the new legislation doesn't explicitly refer to those areas like employment law and human rights law and WSIB. It gives that flexibility or that the definitional ability to our funder. We will once again reaffirm that has to happen at the local level. That is very much consistent with the principles that are enunciated in this government's 2019 budget, where it said that decision-making and services should be community-oriented with a lens and with a focus on the needs of the specific community, as opposed to some bureaucrat somewhere else in the other side of the province.
If I may, thank
I
you
think
very
we
much.
might be out of time.
We're out of time. Thank you, MPP Park. We'll now proceed to the independent member for 4 minutes of questions.
Thank you, Mr. Chair. The question is for Omar again. I wanted to touch upon something that you mentioned in a proposed change. So you did comment on the fact that typically people receiving legal aid services demonstrate a sense of distrust towards government institutions. I want to know if you're concerned with this new power that the government would have to appoint a majority of board members on the Legal Aid Ontario board. So could you give me your sense on that and the impact it would have on the image of impartiality that such a government institution should uphold?
Certainly. It's worth saying that governments obviously come and governments go. And so the structure and the reformulation of the services that we provide through Bill 161 really needs to take a longer view perspective. And so perhaps there's a level of comfort in terms of this government and who they may appoint in that respect. But at some point in the future, it's inevitable, it will be a different government. And so we need to ensure that when we're talking about poverty law and we're looking at the needs of low-income people, that is done in a non-partisan way. Centralizing that and having that in the hands of the funder is not going to achieve that goal. It's also going to, as you indicated, create greater distrust because you have decision-making and priority-making occurring from individuals who are not known in the community and who are completely removed from the community and may be actually emphasizing or prioritizing needs that aren't actually reflected at the local level. And so it is important, that was one of the foundational concepts highlighted in the Ulster report, to maintain the trust, to build the trust and build those bridges with those communities that are already feeling marginalized and are not accessing the resources that are there that are being provided by the government.
Thank you for your answer.
Thank you. We'll now proceed with back to the official opposition for 5.5 minutes. I recognize MPP Yard.
Thank you, Chair. I'm gonna stick with Omar. He's still on the hot seat. I just wanted to ask you. I'll try not to repeat some of the questions from MPP Singh regarding justice and value for money. We talked a little bit about that with yesterday's witnesses. I'm just curious if you think that if this bill passes, would it reduce the areas of law that clinics work in? Say, for instance, eliminating focus on crucial issues like discrimination and human rights. Do you think that would happen?
It's inevitable that that would happen, especially based on how poverty law is defined in the Act. I think I'll also speak to some of the comments that were made yesterday at the committee, which is that increases in legal aid and specifically in the clinics have indeed been demonstrated to show an increase in services. I know there was some questions around that, and we make reference to that in our submissions explicitly at footnote 25, where we refer to the Office of the Auditor General's 2018 annual report, where legal aid services are examined. So there is a direct impact on services that would occur from prioritizing and restructuring things in this particular way. There's a need, as I've said repeatedly now, for that to happen at the local level and to look at the local needs. And I'll use another example of our year-round tax clinic that we have, and the fact that many of our constituents don't do their taxes. Again, they're feeling disenfranchised from the system, and so they haven't filed their taxes or feel as if they haven't been working, so they don't need to fill their taxes. And by providing them taxes or having their tax returns done for them for free, they're actually able then to access additional funding and grants that are available from the government. In other words, we're able to bring things from things like the federal government and federal benefits that might be available to the local level. Investments and money that would not otherwise be there that's now being spent in the local economy. I would suggest that in the COVID-19 and post-pandemic era, where we're going to see an increase in unemployment, we're going to invariably see either a recession or a depression, the role of community legal clinics to be versatile and to be attentive to the needs of their local communities is absolutely paramount.
Okay, my second question to you, Omar. I know Ms. Waddell kind of talked about it as well briefly. Would you say that the system as it is right now is broken, or does it need fixing?
As I said when I alluded to the access to justice crisis, there is no dispute anywhere in the justice system or in the profession that our legal system is broken. Anywhere. I will commend this Attorney General, and Ms. Parks obviously is involved with those initiatives, for some of the modernization steps that they have taken, including remote hearings and the use of technology. And we do expect that that will improve over time, but it's not going to be enough. Access to justice, as we detail in our submissions, is not simply a matter of throwing money at a problem. That's not going to fix it. We need to transform our system, and we need to transform it specifically in light of marginalized populations and the people who don't have lawyers in their back pocket or in their families. And that those are the clients that we actually are serving on a regular basis in our community clinics.
I'll turn back to Omar with the Durham Community Legal Clinic and just ask, I found your evidence helpful. And so I just wanted to ask one specific follow-up question. Some stakeholders have emphasized the importance that the process Legal Aid Ontario undertakes to determine how to provide legal aid services in the area of poverty law, that it needs to be transparent and based on credible data from all stakeholders. Would you be in favor of ensuring that Legal Aid Ontario be required to consider certain types of information it receives from all relevant stakeholders in making these decisions? I just wanted to see if you had a particular perspective on that.
I do. I think that accountability is important for any taxpayer money, so that's really not a contentious issue. What I will say is that there have been efforts underway for years now where Legal Aid Ontario has been trying to identify and develop the metrics in which to do so. The concern may be, from a clinic level, is that because we are all very much focused on providing services, that if there is a shift of an emphasis on reporting, that's going to unduly increase administrative costs. And I think the concern there would be that would be also an unnecessary use of taxpayer dollars if that's not properly and construed and streamlined in a system that is quick and efficient. And we're not entirely clear that that's what's going to transpire.
And just to follow up on this, I'm just trying to wrap my head around it. Like, what types of information do you think stakeholders could provide to Legal Aid Ontario that would be helpful to them in making these determinations?
Just about a minute, 15 seconds.
Part of it is going to be, again, coming from the community legal clinics to Legal Aid, because we have that information as to what the needs are. But I think part of it is better reporting and through a system that actually is streamlined. So there is a system that has been developed within Legal Aid Ontario for reporting back to them certain quantifiable data, but it isn't a system that is necessarily efficient or streamlined. And so there is a considerable amount of time and delay from an administrative perspective that goes into using those systems already. And so that is my biggest concern, is that we want accountability. We want to be transparent about how we're spending taxpayer dollars, but we don't want to have to try to do that in a way that's going to spend more taxpayer dollars on administrative tasks. And I think that's the inherent tension that we're looking at.
Okay. Thank you very much, Ms. Park. I want to thank our first panel of presenters. Again, this was a very interesting discussion. And also, I want to thank Omar in particular for coming back to our committee and again offering his perspective to us. And Ms. Waddell, also thank you for coming back and offering some additional insight. So with that, we will say goodbye to our first panel and thank them again for their submissions.